Good morning everyone and welcome sa isang video on obligations and contracts, the nature and effect of obligations. That is chapter 2 in the obligations and contracts, the Civil Code of the Philippines. Now, we already know that the Civil Code of the Philippines governs relationships among individuals, especially interpersonal relationships between individuals and other people, as well as individuals and juridical persons. So today we will be discussing chapter 2 of book 4 of the Civil Code of the Philippines, the nature and effect of obligations. And we know already that this chapter 2, nature and effect of obligations, is covered by articles 1163 up to article 1178. So let's proceed. So as a context, we know that these articles in the Civil Code on obligations and contracts, and specifically on the natures and effects of obligation, ay basic foundation ito sa pag-solve ng cases, ng issues, no, involving obligations, especially contractual and legal obligations. So, karamihan sa mga kaso natin o mga usapin o mga issues ay nasa-solve through these articles, no? And these are really basic, no? Not complicated articles, no? It really are important in the governance of our interpersonal relationships. So, sige, proceed tayo sa mga articles. Article 1163, every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So, sinabi natin, basic, na kung ikaw ay may obligasyon sa batas man ito o sa kontrata na i-deliver ang isang bagay, automatic yon na alagaan mo yung bagay na nakaatang sa'yo before delivery, no? With a proper diligence of a good father of a family. No, ito yung pinaka-required due diligence, yung maging ama sa isang pamilya, maging mabuting ama sa isang pamilya. So, kung titingnan mo mabuti, ang mabuting ama sa isang pamilya ay mataas na uri ng pag-aalaga sa gamit bago ito maibigay, no, sa taong pagbibigyan. So, but this is just the default, no? So, ito na yung pinaka-standard of care, the diligence of a good father of a family. So, kung halimbawa ang isang bagay ay nasa aking possession and then I am obliged to give it to you in 3 days, I should take good care of it na hindi ito mawala, hindi ito masira bago ito ma-deliver sa iyo. So, basic yon, no? Pero mayroon pang exemption doon kung kailangan ng mas mataas na standard of care. No? For example, contractually, we agreed na I needed, no, to really exercise a higher standard of care, or in the case of common carriers and transportation, the law requires another standard of care, then that should be followed. Napansin nyo ba na kapag tayo ay sumakay ng eroplano, kailangan nating maging maaga sa airport because of the standard of care required by the airport, by the air carriers, no? Kailangan i-check ang mga gamit ng ibang pasahero at ng ating gamit na dapat walang mga contrabands, dangerous items, pointed objects, no? And even liquids na maaring mag-cause ng harm o maaring mag-cause ng disruptions sa operations ng plane. No? So, because of the higher standard of care required by law, and that's extraordinary diligence. No, medyo mataas. So, sa makatwid, ang pinaka basic o default standard of care is that of a good father of a family, and there are other standards of care depende na sa stipulation ng parties o kanilang pinag-agrihan, at minsan the law requires another standard of care like extraordinary diligence or care required on air carriers, no, aircrafts, no. Okay, sa ating aviation laws, no. Ayan. So this is very important, and this is very foundational. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family. Unless the law or the stipulation of the parties requires another standard of care. Article 1164, the creditor has the right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. So this is also very logical. Um, when the obligation to deliver the thing arises, if it bear fruits, then automatically it belongs to the creditor, no? However, hindi muna niya makuha yung real right until ito'y mapasakamay sa kanya, no? Um, we already remembered na kapag there is already the obligation to deliver a dog, for example, uh, to the creditor, no, to the owner, doon sa rightful na parent ng dog, along the way, the dog pala got impregnated and delivered puppies, no? The puppies belong now to the the parent, no? The dog parent, the parent of the dog. Kasi the dog is to be delivered na. The obligation to deliver the dog safely to the parent has already arisen, no? So we know that in civil code, mayroong tatlong uri ng fruits that may accrue to the creditor, to the owner, no? Natural fruits, industrial fruits, at saka civil fruits. Yung natural fruits, yun yung mga spontaneous products ng soil, and the young and other products of animals, no? For example, kung ibigay na sa iyo yung lupa, the obligation to deliver a parcel of land has already been arising, no? Tapos all the trees, no, all the fruit of the trees of that land, no, without human intervention, no, without industry, then they are called natural fruits, and they are to be delivered as well, no? So dahil iba na may-ari ng lupa, no, kahit hindi pa ito na-deliver, mahalaga na kanya na ang ang natural fruits ng nasabing lupa, no? Ayan. So there are also civil fruits, no, those that are derived by virtue of juridical relations, no, such as rent ng buildings, price ng lease of land, no, at iba pa. No, for example, yung building na yon ay iba na yung may-ari, no? From the time na nagbago, nag-change ang ownership, no? And the obligation to deliver the building to um, the new owner, transfer the title of the building to the new owner already have a reason, then automatic yung civil fruits noon, yung mga rents ng building, yung mga kita ng building sa bagong owner na. And then there are also industrial fruit, no, yung produced by the lands, no, of any kind through labor or cultivation. No, for example, yung sugar cane sa lupa, no, mga gulay, mga rice, no, yung mayroong human intervention, eh, dapat i-deliver na rin kasi iba na yung may-ari, no? So, logical siya kasi alam naman natin na ang pagmamay-ari ng isang um, ari-arian, no, ay ikaw na rin ang may-ari ng bunga nito, no? Ayan. So kapag sa'yo na yung lupa, lahat ng bunga nito, maging civil fruit man, industrial fruit man, o natural fruit, sa'yo ito, no? Ayan, sa owner ito, no? Ayan. Kaso nga lang, yung real right, no? Ayan, yung yung possessory, yung ownership right, no? Ay hindi pa napasayo kasi to be delivered pa lang siya, no? Okay. Okay. So siguro let's proceed to another article. Article 1165, when what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. So foundational din ito, no? At marami din tayong mga issues at mga sigalot na nasa-solve through Article 1165, no? Kung ang i-deliver ay determinating, ibig sabihin na-determine na ito, na-segregate na, identified na specifically, no? Kailangan na itong i-deliver, no? The creditor may compel the debtor to make the delivery, no? Specific yung gamit, no? So hindi siya generic. No, for example, pera, very generic. Any money ay pwede mong ibigay. No, pero pag sinabi mong specific, tulad ng kotse na may chassis number, may kulay, no, mayroon ng identified na, no, pointed out na, then hindi pwede siyang i-substitute, no. Yun talaga ang iyong i-deliver kasi identified na yon by the creditor. Determinating na siya, no? And then kung generic naman o indeterminate, so pwede siyang mapalitan, no? But at the instance and at the expense of those who will deliver it, no? For example, money, very indeterminate or very generic. Any serial number of the money, no, will, you know, comply with the obligation, will satisfy the obligation, no? Ayan. So, what if the obligor delays? No, the third paragraph answers. If the obligor delays, no, or if in some fraudulent transactions, no, the debtor has promised to deliver the same thing to two or more person who do not have the same interest, no? So the consequence is, if it happens na the object, no, got lost, no, because of some event, fortuitous event, no, then responsible pa din ang debtor, no? Kasi in some instances, kapag the object is lost beyond recovery without the fault of the debtor and through a fortuitous event such as yung calamities, no? Nasira yung deliverable na kotse because of flood, no? Then sometimes the debtor is already free from the obligation, no? He is already um, because of fortuitous event, he is already free from delivering the object, no? However, kung ito yung nangyari na delay niya or na fraudulently promise niya ito sa iba't ibang tao na merong magkakaibang interest, then kahit may fortuitous event ay siya ay um, obliged, no, to effect the delivery. Okay. So, puntahan muna natin yung 1170 kasi may additional na matatanggap na um, right ang isang creditor, no? Okay. So as was said in the previous article 1165, no, when what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. So what is Article 1170? No, may additional right kasi ang creditor dito. So 1170, those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor of thereof are liable for damages. So, in addition, pwede pang maningil ng damages, no? Damages na civil, no? Damages moral, damages, no? Kasi the creditor was wronged, no? May ginawa sa kanya na mali, no? So the creditor can actually ask for damages in addition to the demand for the delivery of the thing, no? Like for example natin, um, I buy a car, no, from a car company, no? And then yung gusto kong car is orange, no? And meron ng plate number. The plate number is 606. No? Although, kasi second hand yung car na binili, so meron na siyang registration. No? So, I was so interested, no? And I was so happy, no? And little did I know na it was promised to many people. So, hindi ko siya nakuha. Nakuha ng iba na mas mabilis sa akin, nauna sa akin, no? But I already paid. No, so the object now is determinate, no? Yung the object to be delivered is determinate. I already identified it, no? I already particularly segregated it from all other cars. Kasi pwede naman any car, no? But that was the specific car of choice. So, nung hindi siya ma-deliver sa akin because of um, fraud, no, or negligence or delay, then I can demand for the delivery. Of course, I have the right na bayaran ko na yon plus the damages kasi it cost me syempre stress na yung car na napili ko has been, promised to others. It cost me sleepless nights. It cost me undue anxiety, no? It cost me stress in general. No, so Article 1170 allows me for some damages, no? Allows me to claim damages against the person who did cause me stress. Yun yung maganda dito sa um, laws natin, no? It is really fair, no? Ayan, so you cause me stress, then I can claim damages, no, from the stress that I suffered. So, what about fortuitous events, no? Like mentioned, no? If the obligor delays, a third paragraph, if the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event, no, until he has effected the delivery, no? So yung delay, no, like the period of delay, no, is there is uncertainty na within the period of delay hindi ko pa nakuha yung car, no, may mga chances are ma mawala siya in transitu, no, habang papunta sa akin, mawala siya along the way, o kaya'y masira siya along the way, no? So, indeed, kapag may nangyari sa kanya during that delay period, fortuitous event man ito, yung mga accidents, no, acts of God, acts of nature, no, liable na for damages ang obligor, no, yung debtor or obligor. Liable na for damages, liable na rin siya for any loss. No? So, indeed, kapag may obligations tayo, gaya ng previous paragraphs, we are supposed to deliver the deliverable with the diligence of a good father of a family, because we are very much liable, no? Not only for the cost of the thing itself, but also for the damages that you cause dun sa creditor, no? 1166, the obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned in the contract, for example, no? So everything that is um present with the object for the enjoyment of such object, no, must be delivered together with the object, no. Yung kanyang mga accessories, no, yung kanyang um, sessions, no, kasi these are important for, no, the person, the owner, to actually enjoy the thing, no? Kasi how can you enjoy, for example, a thing na ang dami niyang nawawala, no? Okay. So, uh, let's define accessions, no? Accessions are the fruits of or additions to or improvements upon the thing, the principal, no? Example, yung house or trees on a land, no? Okay, if the principal is the land, no? The trees on the land or the house on it becomes the accessions, no? Okay, if the principal is the building, yung pinadi-deliver sa building, yung rents ng building ay accession, no? Kung car, yung aircon, yung accessions yun, no? Ayan. So, ang hirap mong i-enjoy yung car kung mainit siya, no? And of course, you wouldn't buy it kung walang accessions, no? Okay. So, for example, yung mga lupang binili mo, no, meron siyang um, mga natural accessions, no, yung mga trees na nandun. So, or mga lupang kumabit doon, no, by action of nature, like yung rivers. These are all accessions. Accessories are things joined to, included with the principal, no, for the latter's embellishment, no. Ayan, or better use or completion, no. Halimbawa yung sa watch, no, yung bracelet niya, accessory yun. Kasi paano mo magamit yung watch kung wala siyang bracelet, no? Or ah, sometimes yung mayroong picture na maganda, no? And then nung nakita mo naman may frame siya pero nung dineliver wala na yung frame, accession kasi yung frame doon, no? Ayan. So, paano mo ma-enjoy yung violin kung wala yung accession na vow, no? Bow. Paano mo ma-enjoy yung car kung tinanggal yung stereo, yung music niya, no? Ayan. So, these are accessions, no? So, as a general rule, all accessions, no, and accessories are actually included, no, in the obligation to deliver. Kahit hindi ito nabanggit, kung necessary naman ito, desirable, then isama dapat siya sa pag-deliver. Unless otherwise stipulated, no? Kung meron kayong agreement na hindi siya kasama, no? Okay. So, let's see. 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost, no? The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone, no? So fair enough, no? Kung um, the person is obliged, no, by contract or by law, no, to do something and he fails to do it, no, it shall be executed at his cost. The same rule, no, is observed if he does it though, pero not, no, in accordance with what is agreed upon, no? And then what may have been poorly done be undone. I remembered na there was a case na yung wife niya namatay. And then, ang huling wishes ng wife niya ay mailibing siya bago magpasko. So, namatay siya um, 3 days before Christmas. And then, ang huling habilin niya mailibing siya agad, no, bago mag-Christmas. For a reason, you know already what the reason is. Ayaw niyang mag-Christmas yung family niya na malungkot. So yung husband niya contracted with a supplier na to deliver all construction materials before Christmas, no? And a supplier agreed, no? So ngayon nag-renege yung supplier sa kanyang contractual obligations. Bale, hindi niya na-deliver on time ang construction materials. So yung mga workers, laborers, mga panday, mga trabahador ay naghintay, no? Ready to do the job as wished by the wife. Pero wala, hindi dumating ang mga construction materials. So the husband, no, stressed out at hindi niya masunod ang huling wishes ng wife niya, kumuha sa iba, no? And of course, according to Article 1167, the same shall be executed at his cost, no? So ang magbabayad nun yung supplier na hindi nakapag-deliver, no? Kasi bayad na siya and he's obliged already by contract and by law to deliver, but fails to do it. So since ginawa ng iba, dineliver ng iba, it should be at his cost, no? So same rule kapag ka nagpagawa ka ng bahay, for example, but it looks like it was done in contravention of what you agreed, no? Hindi siya maganda para sa iyo, at hindi lang sa hindi maganda, hindi nasunod ang gusto mo, no? Or in some other cases, poorly done, no? So same rule, it shall be undone at the cost of the obligor, no? Or what has been poorly done be undone, no? So sabi ng professor ko sa English dati, no, if you cannot do it, then just be honest, don't do it, no? I remembered na nagpa-xerox siya ng mga examinations, and then to his dismay, uh, yung mga examinations na pinagawa niya ay hindi mabasa, masyadong malabo, no? So there was negligence and failure, no, to deliver on the part of the uh, debtor, no? Sabi niya, sana if you cannot do it, just don't, no, enter into such obligation. Do not promise something that you cannot do, no? Ayan. So what the professor did is to have the exam photocopied, no, sa ibang photocopier company, and then pinabayaran niya dun sa company who fails to do it, no? And that is exactly allowed in Article 1167. Let's proceed with Article 1168, no? When the obligation consists in not doing and the obligor does what has been forbidden of him, it shall be undone. Also, it shall also be undone at his expense. No? So, when what was agreed is for you not to do something, but you still did it, no, then it shall be undone no, at your own expense. Very foundational but very important articles, no. So Article 1169, those obliged to deliver or to do something incur delay from the time the obligee judicially or extra demands the fulfillment of their. However, shall not be necessary in order that this will the obligation or the law expressly so declare. Number two, when from the nature and circumstances of the obligation it appears that the designation of time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract. Or number three, when the demand would be useless, as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one party fulfills his obligation, delay by the other begins. So Article 1169 defines delay, no? So when is a person in delay, no? Kailan ba nadidelay yung isang person, no? Yan talaga ang una kong question noon when I was a lawyer, no? Kapag naniningil ka, no? Pupunta ba agad sa korte para maningil, no? File ba kaagad ng kaso para maningil? The answer is no. Mag-judicial or extrajudicial demand ka muna. Mag-demand letter muna, no? So that ma-establish na nagkaroon na ng delay, no, na hindi na niya nagagawa on time yung kanyang obligation, no? Ayan. So there are instances when demand letters or demands are not necessary. There are three instances na nilagay ang law, no, 1169. So ang number one is kung nandun mismo sa contract, no, the obligation or the law, nandun mismo sa law na ang deadline, no, or ang kapag di mo nagawa, delay na yun, no. So no more need for judicial or extrajudicial demands, no? Wala nang need for a demand letter kung nandun na mismo sa obligation stipulations, no? Or kung makikita naman natin sa nature kung ng contract na time is of the essence, no? Tulad ng example natin kanina na alam naman ng obligor na ang wish ng wife is to be buried before Christmas. So it was like in a rush. No, so magdi-demand letter pa ba tayo? No more, because in the nature and the circumstances, no, it already appeared na time is of the essence. And then useless naman na sa third instance, useless na yung demand kung hindi naman kaya talaga ng obligor i-fulfill yung kanyang part, no, sa deal, no. So no more demand kasi it's already like superfluous na, useless na yung demand, no. For example, nag-bankrupt na yung company, no, so hindi na niya mare-return ang mga investments, hindi na niya ma-deliver ang kanyang mga na-promise. So what's the demand for? It's already beyond the power of the obligor to perform. What about reciprocal obligations? Yung you give, I give, no? Yung kaliwaan, no? Tinatawag, no? Paano kung hindi ka pa naman nagbigay, di pa ako delay, no? Di pa ako nagbigay, di ka pa delay, no? Okay. No, I give that you may give. I do that you may do. Di mo pa naman ginawa, no? Di pa ako delay, no? Reciprocal obligations, no? Neither party incurs in delay, no? If the other does not comply or is not ready to comply, what is incumbent upon him? But from the moment one of the parties fulfill the obligation, the delay by the other begins. No? Kasi kaliwaan nga, no? Reciprocal obligations. So, well, most obligations are reciprocal. No? If I, yung mga ordinary obligations, kaya most, no? If I give the money, then you give me the object I wanted, no? Like buying basic needs in the grocery, I get the grocery, I pay, reciprocal, no? But if I get the grocery, I didn't pay, no? Ayun, delay na, no? I didn't pay. Kailangan pang mag-demand letter for me to pay, no? Delay na. So sa reciprocal obligations, kaliwaan talaga siya. When one of the party already comply, then you are to comply. 1170 na ano na natin 'to, no, na-discuss kanina, no? Those who in the performance of their duties or obligations are guilty of fraud, negligence, or delay, no? When I was a student, FND, fraud, negligence, or delay. And those who in any manner contravene the tenor thereof are liable for damages. So kanina, delay is defined, no? Kailan nagkakaroon ng delay? In general, mag-demand letter, no? Or may mga instances na hindi na kailangan, tapos meron ding sa reciprocal, it arises when the other party complies, no, with what is incumbent upon him. No, this naman, kung it happens na may delay, liable na kaagad for damages. 1171, no? Responsibility arising from fraud is demandable in all obligations, no? Any waiver of an action for future fraud is void, no? So yung panloloko, no? At nanloko ang isang individual, no? Kailangan responsible siya doon sa ginawa niya, no? And that cannot be waived, no? Hindi pwedeng baliwalain, no, ang kalokohan, no? At saka like once niloko mo ako, di ako mag-file ng action, oh, that word is void, no? Okay. So 1172, responsibility arising from negligence in the performance of every kind of obligation is also demandable. But such liability may be regulated by courts according to circumstance. We already know na yung negligence may mean lack of skill, lack of foresight, no? Kakulangan sa pag-iingat, no? Kakulangan sa kakayanan na na mag kakayanan na gumawa doon sa agreed na obligations, then those are actually negligence, no? Ayan. So, of course, kapag negligent ang isang tao is liable siya for um, damages, no? And responsible siya for damages. Okay, so Very easy, no? Not complicated, no? Actually. So, in general, no, the law allows uh, claims for damages, especially um, on delay, NDE, negligence, no? Delay and fraud, no? Ayan. So, let us mention some of them, no? Yung negligence, for example, and fraud, very important, no? Um, sa fraud, may panloloko, no? Pero sa negligence, walang ganong intention, no? Pero kung ang negligence ay pinapakitaan mo din na parang baliwala lang, gross, no? And it shows bad faith or malice, magkapareho na yun, no? Negligence and fraud becomes equal, no? Ayan. So, gross negligence, yung absence, no? Or failure to exercise even the slight care or diligence, no? Or the entire absence of care. Grabe naman. Diligence, no? Lack of skill, lack of foresight, absence of care, kakulangan sa pag-ingat, no? Pag-iingat. Okay. So 1173, the fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstance of persons, of the time, and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 202201 paragraph 2 shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected again of a good father of a family shall be required. So, when do you consider fault or negligence of the obligor? Kailan siya nagkaroon ng negligence, no? Nagkaroon siya ng negligence kung hindi niya ginawa yung diligence na required sa kanya ng batas at saka nung nature ng obligation. No, kung walang requirement, then yung good father of a family na naman, no? Ayan. So, Article 1174, except in cases expressly specified by law or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. So this refers to fortuitous event, no? Okay. May mga cases specified by law, no, or otherwise agreed upon, no, by the parties, no, or the nature of the obligation requires the assumption of risk, no? Lahat ng tao na nakaranas ng fortunate and was not able to deliver what is incumbent upon him, hindi siya maging responsible for it, no? Kasi aksidente 'yon, acts of nature, no? So hindi niya kasalanan or force majeure, nagkaroon ng giyera, nagkaroon ng pandemic, so di niya na-deliver yung deliverable niya. So hindi siya responsible. Pero may mga exceptions to the rules, no? Like when the law specifically says so, or nag-usap sila na no matter what, i-deliver niya. And then, or yung nature naman talaga ng obligation, no? requires the assumption of risk. No, natawa ako dito sa nature of obligation requires the assumption of risk. No? There was a case ng mga windmills, no windmills. No? Ayan, yung nasira yung ibang mga windmills tapos kinasuhan ngayon ng um, may-ari nung windmills yung contractor, yung nag-construct ng windmills, no? Kasi nasira siya, no? Lakas ng hangin, no? And yung defense nung construction company is fortuitous event, no? There was an lakas ng hangin and therefore it destroyed the windmills. So such assumption, such type of wind, kasi wind siya natayo sa mahahangin na lugar na malalakas na hangin, no? So uh, you know, responsible pa rin yung construction company dun sa windmills, no? Kasi kasama yun, no? Yung hindi siya fortuitous event, kasama yun sa risk na ina-assume nila, no, when you construct a windmill, no? But for all other cases like yung natamaan ng kidlat, no, lightning strikes, no, and then natamaan ng kidlat halimbawa yung gulong ng sasakyan and then sumabog, it caused um, you know, accidents, ganon. So parang fortuitous event siya, no? It cannot be foreseen, no? Even if foreseen, it cannot be, avoided, no? So why would you hold a person responsible for unforeseen, like you know lightning strikes, no? So parang this talks about fortuitous event. So let's define fortuitous event, no? Okay, this is not part of the law. This is just a definition. Fortuitous events, no, by definition, are extraordinary events foreseeable or avoidable to constitute fortuitous event. No, this is a part of a jurisprudence, no, bahagi ito ng desisyon ng court. To constitute a fortuitous event, the following elements must concur. Okay? A, the cause of the unforeseen and expected occurrence, no? Or of the failure of the debtor to comply with the obligations must be independent of human will. No, so yung unforeseen, unavoidable circumstances must be independent of human will, including yung ability or failure of the debtor to comply with the obligations. It must not be beyond, no, human will. It must be impossible to foresee the event that constitutes caso fortuito. If it can be foreseen, it must be impossible to avoid. The occurrence of such the occurrence must be such as to render it impossible for the debtor to fulfill obligations in a normal manner. And the obligor must be free from any participation in the aggravation of the injury or loss. No, ayan. So fortuitous event, no, is it will free the obligor from any obligation or from any what is incumbent upon him. He may not do it anymore because of the fortuitous event, no, but all these elements must concur, no? Ayan, in as much as it frees the debtor with the compliance of his obligations, all these elements A, B, C, D must concur, no? So number one, independent of human will. Though the thing that he claims to be casa fortuito must be independent of any will at all. So number two, no, it was impossible to foresee, and even if foreseeable, like typhoon, it's impossible to avoid. No, and number three, um, the occurrence, no, what happened renders it impossible for the debtor to comply or to fulfill the obligation. Number four, no, the obligor must be free from any participation. No, ayan. So that's in one case, no, that the decision that the Supreme Court decided, no, ayan. Shall be governed expression yung insurance transactions refers to yung engagement na medyo mataas yung interests, no? Ayan. So, in the Philippines, we don't have usury laws anymore, no? Uh, the parties can actually enter into an agreement as to how much, no, interests are to be imposed on certain obligations or certain indebtedness, no? Ayan, or investments, no? 1176, no? The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that the said interest has been paid. The receipt of a later installment of a debt without reservation as to the prior installment shall likewise raise the presumption that such installment have been paid. No? So 1176 are all about presumptions. No? Kung matanggap na ng creditor yung pinaka-principal amount, no? At wala na siyang tinutukoy pa na mga interest, so bayad na ang interest. Yun yung presumption, no? Kasi nakuha na niya yung amount na ni-loan niya, so it gives rise to the presumption na the interest has already been paid, no? Okay. Although it may not have been paid but just waived by him, the presumption is the interest has already been paid, no? Kung installment basis naman yung payment, no? For example, mayroong latest receipt yung debtor na he's already paid as of the month of October, then yung previous months is presumed to be paid already. Previous installments, no, have already been paid, no, sa previous to the October installment, no? Kung monthly siya and then meron na siyang resibo ng October 2024, so the presumption is yung September 2024 and prior to that are already paid, no? So this is a logical presumption. Article 1177, the creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all rights and bring all actions to the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts of the debtor that may have which the debtor may have done to defraud them, no? So this pertains to the rights of the creditor, no? Kahit nakuha na niya yung possession dun sa kiniklaim niya, mayroon pa siyang other rights. He may exercise all these rights, no, to bring claims, no? Okay. And sometimes, no, may mga debtors na dali-dali nilang i-dispose yung mga gagamitan nila para walang mahabol yung creditor, no? The creditor can actually impugn it, no? Can actually invalidate, void, no, through courts, of course, the actions that are done para siya lokohin or para i-defraud siya, no? So dali-dali nilang binenta yung mga ari-arian nila. So mahahabol pa ito, no? But there are of course time limitations on this, no? It must be done as soon as possible. No, as of now, maraming laws involved dito, no? Ayan. So 1178, no? Subject to the laws, all rights acquired in virtue of an obligation are transmissible, no? If there has been no stipulation to the contrary. No, so save na save stipulation to the contrary or the laws, no? Transmissible, transferable yung mga rights na ma-acquire by virtue of an obligation. Pwedeng i-transfer, no? For example, yung sisingilin ko sa inyo, i i-transfer ko na lang sa iba. Siya na ang maningil, no? Sige, mayroon akong collectible sa inyo, ilipat ko sa iba. No? Okay, can you collect na lang so that yung obligation ko sa iyo ay um, ano na din, ma-satisfy. Can you collect from this? I can actually transfer, no? But of course, if there is a stipulation na it's not transferable, or if it's against the law or public policy or rules, no, then it cannot be um, allowed, no. But in general, obligations are transmissible, no, can be transferred to another person, no. So these are all the foundational um, rules for obligations, no. So in general, maraming mga issues, usapin na ah, galing lamang, no, sa rules na ito. I mean, nasa-solve lamang ng rules na ito, no? Kaya sabi nga natin, civil code rules, rules of conduct, no, for interpersonal engagements, no, like interpersonal relations, no. And that would be it for the nature and effect of obligations. There are, of course, complicated rules on this, but this is to simplify only, no, these rules for the enjoyment of common citizens, no. So thank you for listening, and good day, good morning again.